I never thought I would become the kind of person who spends hours reading property law statutes at 2 in the morning. But there I was, coffee going cold on my desk, highlighter in hand, ready to go to war with my homeowners association over a sewer line running through my backyard. My name is Keith Zimmerman, and this is the story of how the Lakeview Estates HOA made the biggest mistake of their bureaucratic lives when they decided my lakefront property was theirs to use however they wanted. It started on a Tuesday morning in late March 2024. I was out on my deck overlooking Lake Hartwell in South Carolina, enjoying my coffee and watching the mist rise off the water. I'd bought this property 3 years earlier after selling my software company, and it was everything I had dreamed about. 2 acres of prime lakefront land, a modest but comfortable house, and most importantly, privacy. The nearest neighbor was a quarter-mile down the shoreline, and I could walk out my back door straight down to my private dock without seeing another soul. That morning, though, something was different. I heard machinery, heavy machinery, the kind of diesel rumble that tells you someone is doing serious construction work. I set down my coffee and walked around the side of my house toward the sound. What I saw made my blood run cold. There were 3 workers in hard hats, a small excavator, and a massive trench carved through my side yard, running from the street all the way down toward the lake. They had already dug maybe 200 feet of a 3-foot deep trench, and orange construction fencing marked off the area. I ran down there, still in my bathrobe and slippers. "Hey, what the hell are you doing on my property?" One of the workers, a guy in his 50s with a weathered face, looked up from the trench. "HOA sewer project, sir. We are just doing what we were contracted to do." "HOA sewer project? Nobody asked me about any sewer project. This is my land." The worker shrugged. "You will have to take that up with the HOA, buddy. We got permits and everything. We are just the crew." I pulled out my phone and started taking pictures. The trench cut right through what had been a beautiful natural area with mature hardwoods and native plants. They had already taken out 2 old oak trees that must have been 70 years old. The path of destruction ran in a perfectly straight line from the road toward the lake, ignoring the natural contours of the land completely. "Stop. Right now. Stop digging," I said, my voice shaking with anger. The foreman came over, clipboard in hand. "Sir, like I said, we have authorization. You're going to have to call the HOA if you have a problem. We have a schedule to keep. I'm telling you right now, as the owner of this property, you do not have permission to be here. Get off my land." The foreman's expression hardened. "We have a contract with Lakeview Estates HOA. They told us we have right of way. Now, you can call them, or you can call the police, but we are going to keep working until someone official tells us to stop." I called the police. Officer Daniels from the Anderson County Sheriff's Department arrived about 20 minutes later. By then, the crew had dug another 50 feet. I met the officer at my driveway, still fuming. "What seems to be the problem, Mr. Zimmerman?" Officer Daniels was a tall guy, probably in his early 30s, with a calm demeanor that I appreciated even in my agitated state. I explained the situation, showing him the destruction in my yard. He walked down to look at the trench, talked to the foreman, looked at some paperwork, then came back to me. "Mr. Zimmerman, they have a work permit from the county and documentation from your HOA. As far as I can tell, this is a civil matter between you and the HOA. I cannot order them to stop based on what I am seeing here." "This is my property. They are destroying my land." "I understand your frustration, sir, but if the HOA has the legal right to do this work, then it is not trespassing in the criminal sense. You need to contact your HOA immediately and get this sorted out. If they do not have the proper easements or permissions, then you need to pursue that through civil court. I am sorry, but my hands are tied here." After Officer Daniels left, I stormed into my house and called the HOA office. A perky receptionist answered. "Lakeview Estates HOA. This is Jennifer. How may I help you today?" "This is Keith Zimmerman on Shoreline Drive. There are workers digging a massive trench through my property right now, and nobody asked me for permission. What the hell's going on?" "Oh, let me transfer you to Mrs. Patterson. She is handling the sewer project." The hold music was some kind of easy listening jazz that made me want to throw my phone across the room. After what felt like an eternity but was probably only 2 minutes, a woman's voice came on the line. "This is Brenda Patterson, HOA board president. Mr. Zimmerman, I was wondering when you would call. You were wondering? You were wondering when I would call about the destruction happening on my property? Mr. Zimmerman, please calm down. This is a legitimate HOA infrastructure project. The Lakeview Estates community is installing a new sewer line system to service the properties on the north side of the development. Your lot provides the most direct route to the county connection point. You cannot just dig through my property without permission. Actually, Mr. Zimmerman, if you read your HOA covenants, conditions, and restrictions which you agreed to when you purchased your property, you would know that the HOA has the right to perform necessary infrastructure improvements. This is covered under Section 12, Paragraph 4. I had my laptop right there and pulled up the digital copy of the CCRs I had saved when I bought the place. I scrolled frantically through the document while Brenda continued talking. The new system will be a significant improvement for the community. Currently, the north side properties are on septic systems, which, as I am sure you know, are not ideal for lakefront properties. The new sewer line will connect to the county system and provide better environmental protection for Lake Hartwell. You should be thanking us, really. This increases your property value. I found Section 12. It did mention that the HOA had rights to perform maintenance and improvements, but it specifically stated on common areas and with proper easements on private lots. I read it 3 times to make sure I understood it correctly. Brenda, this section says you need proper easements. Do you have an easement on my property? There was a pause. The HOA board voted to approve this project 6 months ago. All the proper procedures were followed. That is not what I asked. Do you have a recorded easement giving you the right to run a sewer line through my property? Mr. Zimmerman, I do not appreciate your tone. We are trying to improve the community. The board has consulted with our attorneys, and we have every right to proceed with this project. The work will be completed within 3 weeks, and your property will be restored to its original condition, minus the unfortunate trees, of course. You will simply have to trust that we know what we are doing. Show me the easement. If you have it, show it to me right now. I do not have time for this. I have a meeting in 10 minutes. If you have further concerns, you can attend the next board meeting on the 3rd Thursday of next month. Good day, Mr. Zimmerman. She hung up. I stared at my phone in disbelief. They were destroying my property. They were dismissing my concerns, and they would not even show me the legal documentation supposedly giving them the right to do it. I immediately called my real estate attorney, Marcus Chen, who had handled my property purchase 3 years earlier. His secretary said he was in court, but would call me back. I left an urgent message. Then I went back outside. The excavator was still digging, the diesel engine rumbling like some mechanical monster devouring my land. The trench was now at least 300 feet long and getting closer to the lake. I stood there watching, feeling completely powerless. These strangers were tearing up earth I owned, destroying trees that had been growing since before I was born, and there was nothing I could immediately do about it. I spent the rest of the day documenting everything. I took hundreds of photos and videos from every angle. I measured the trench dimensions. I identified every tree they had damaged or removed. I made detailed notes with timestamps. If this was going to end up in court, I wanted a complete record. Marcus called me back around 4 that afternoon. I explained everything that had happened, reading him the exact wording from Section 12 of the CCRs. Keith, you are right to be concerned. What you are describing sounds like a potential trespass. The CCRs are clear. They need a proper easement to run utilities through your private lot. Do you have your title insurance policy and the title report from when you purchased? Yes, I have everything in my files. Pull those out and check the legal description and the schedule of exceptions. If there was an easement on your property, it should have been disclosed in the title report. If it was not there when you bought the place and they did not subsequently negotiate and record a new easement, then they are trespassing. I found my title documents. The legal description was straightforward, describing my 2 acres by meets and bounds. The schedule of exceptions listed the usual items: property taxes, HOA CCRs, a utility easement for power lines along the street frontage. There was nothing about a sewer easement, nothing about the HOA having the right to run infrastructure through the middle of my property. Marcus, there is no sewer easement listed. The only utility easement is for the power lines by the street, which is standard. Then they are trespassing, Keith. Here is what we need to do. First thing tomorrow morning, I am going to send a cease and desist letter to the HOA and to the contractor. Then we are going to file for a temporary restraining order and a preliminary injunction to stop the work. After that, we are going to sue them for trespass, destruction of property, and probably a few other causes of action once I do more research. This is pretty egregious conduct. How long will this take? The TRO we can get in a day or two if the judge sees it as urgent, which this clearly is. The preliminary injunction hearing would probably be within a couple of weeks. The actual lawsuit could take months or even longer, depending on how stubborn they want to be. But Keith, I have to tell you, if the facts are as clear as you are describing, they are going to lose. You do not just dig through someone's private property without permission. It does not matter if you are a homeowners association or anyone else. That night I barely slept. Every time I closed my eyes, I saw that excavator ripping through my land. I kept wondering what other damage they would do before we could stop them. By 6 the next morning, I was up and outside. The work crew showed up at 7:30. I walked down to meet the foreman. My attorney is filing papers today to stop this work. You are trespassing on my property without a legal easement. The foreman sighed. Look, man, I feel for you. But we have a contract. Until someone with legal authority tells us to stop, we keep digging. That is just how it works. We got bills to pay too. You are going to be defendants in a lawsuit if you keep going. Then we will be defendants. I have been doing this work for 25 years, and I have seen every kind of property dispute you can imagine. The lawyers sort it out eventually. We just do the work we are paid to do. By 9 o'clock, Marcus had emailed me copies of the cease and desist letters he had sent via certified mail and email to both the HOA and the contracting company. By noon, we had filed our motion for a temporary restraining order with the Anderson County Court of Common Pleas. By 3 o'clock that afternoon, we had a hearing scheduled for the next morning before Judge Harold Simmons. That evening, Brenda Patterson called me. Her tone was completely different from our first conversation, icy and threatening. Mr. Zimmerman, I have been informed by our attorney that you are filing frivolous lawsuits against the HOA. I want you to know that the board takes this very seriously. We have the right to pursue all legal remedies available to us, including sanctions for frivolous litigation and recouping our attorney fees. Brenda, you are running a sewer line through my property without an easement. That is trespassing. This is not frivolous. We have consulted with counsel, and we are confident in our legal position. You agreed to the CCRs when you bought your property. You do not get to pick and choose which rules apply to you. The board voted for this project, and it is going forward. If you continue with this lawsuit, you are going to find yourself on the wrong end of a very expensive legal battle. We have insurance that covers our legal fees. Do you? I have the law on my side, Brenda. You cannot just take someone's property without compensation or due process. Ever heard of the Fifth Amendment? Do not lecture me about the Constitution, Mr. Zimmerman. I have been serving on this board for 12 years, and I know exactly what our rights and responsibilities are. You are being a difficult, selfish homeowner who cares more about a few trees than about the good of the community. The sewer project benefits everyone, including you. Once you calm down and think rationally, you will understand that. Show me the easement, Brenda. If you have it, just show it to me, and this all goes away. We do not have to show you anything. See you in court, Mr. Zimmerman. The hearing the next morning was in a small courtroom on the 3rd floor of the Anderson County Courthouse. Judge Simmons was an older gentleman, probably in his late 60s, with white hair and a no-nonsense demeanor. The HOA was represented by an attorney named Richard Stapleton from a firm in Greenville. He was everything you would expect from an HOA attorney: expensive suit, slicked back hair, and a condescending attitude. Marcus presented our case first. He had the title report, the CCRs, photos of the destruction, and a survey of my property showing the path of the trench. He argued that the HOA was committing an ongoing trespass, causing irreparable harm, and that we needed immediate injunctive relief to stop the work while the case proceeded. Stapleton stood up with a thick binder. Your Honor, this is a simple matter of a homeowner who does not understand the HOA rules he agreed to. My client, The Lakeview Estates HOA has the authority under the CCRs to perform infrastructure improvements. This sewer project was properly approved by the board, properly permitted by the county, and is being conducted in accordance with all applicable regulations. Mr. Zimmerman is trying to hold the entire community hostage because he does not like progress. Judge Simmons looked at him over his reading glasses. Counselor, does your client have an easement on Mr. Zimmerman's property for this sewer line? Stapleton hesitated for just a moment. Your Honor, the CCRs grant broad authority to the HOA to maintain and improve common infrastructure. We believe that authority extends to this situation. That was not my question. Do you have an easement, a recorded document granting you the specific right to run a sewer line through the middle of Mr. Zimmerman's private lot? Your Honor, we are prepared to argue that the CCRs themselves constitute the functional equivalent of an easement for this purpose. Judge Simmons leaned back in his chair. Mr. Stapleton, I have been practicing law in South Carolina for 43 years. I know what an easement looks like, and what you are describing is not one. I have reviewed the CCRs that counsel provided. Section 12 specifically states that the HOA needs proper easements for work on private lots. I do not see where your client obtained such an easement. Your Honor, with respect, the board voted to approve this project. The proper procedures were followed. The board does not have the authority to vote away property rights, Counselor. If the HOA wanted to run a sewer line through Mr. Zimmerman's property, they needed to negotiate an easement with him, compensate him fairly, or pursue eminent domain through the proper governmental channels. They did not do any of those things. They just started digging. That is trespassing, pure and simple. Stapleton looked like he had been slapped. Your Honor, if you halt this project now, it will cause significant expense and delay. The contractor has already been paid for the work completed. The residents on the north side of the development are expecting this connection. Then your client should have thought about that before they started construction without securing the proper property rights, Judge Simmons said. I am granting the temporary restraining order. All work on Mr. Zimmerman's property is to cease immediately. We will have a full hearing on the preliminary injunction in 2 weeks. Is that clear? Yes, Your Honor, Stapleton said quietly. Marcus and I walked out of that courthouse feeling victorious. Within an hour, a sheriff's deputy was at my property serving the TRO on the work crew. The excavator went silent. The workers packed up their equipment and left. For the first time in 3 days, my property was quiet again. But the damage was done. The trench was 350 feet long, cutting a scar through my land from the street almost down to the lake. 2 large oaks were gone, along with probably a dozen smaller trees and countless native plants. The natural drainage patterns had been disrupted. It looked like a war zone. Over the next 2 weeks, Marcus and I prepared for the preliminary injunction hearing. We hired a surveyor to document everything. We got an arborist to assess the tree damage and provide evaluation. We had an environmental consultant look at the potential impact on the lakeshore. We were building an overwhelming case. The HOA, meanwhile, was scrambling. Marcus received a settlement offer. The HOA would pay me $25,000 for the easement, restore the property as much as possible, and complete the sewer line. I rejected it immediately. They had destroyed something irreplaceable, and now they wanted to buy the right to keep their illegal sewer line in place. Not a chance. Brenda Patterson showed up at my house one evening, unannounced. I watched through my window as she got out of her black Mercedes SUV and marched up to my front door. She was exactly what I had imagined. Mid-50s, expensive athleisure wear, the kind of haircut that cost $200, and a facial expression that suggested she had been sucking on lemons. I opened the door before she could ring the bell. What do you want, Brenda? We need to talk, Mr. Zimmerman. This situation has gotten out of hand. You are the one who let it get out of hand. You should leave my property. Please, just 5 minutes. I came here in good faith to try to resolve this. Against my better judgment, I let her in. We stood in my foyer. I did not offer her a seat. Mr. Zimmerman, Keith, may I call you Keith? No, she pursed her lips. Mr. Zimmerman, then, I think there has been a fundamental misunderstanding here. The board approved this project because it genuinely is good for the community. We had engineers study the best route for the sewer line, and your property simply has the best topography and the most direct path to the county connection point. We never intended to harm you or your property. And yet here we are. You cut down 70-year-old trees and carved a trench through my land without asking me. We thought the CCRs covered it. Our previous attorney before Mr. Stapleton told us we had the authority to proceed. This was an honest mistake. An honest mistake? Brenda, you personally told me on the phone that you consulted with attorneys and knew you had the right to do this. Now you are saying it was a mistake? Her expression hardened. I am trying to be reasonable here. The board is prepared to increase our settlement offer to $50,000. That is very generous compensation for an easement and for the temporary disruption. We will restore your property, plant new trees, whatever you want within reason. This is a fair offer. Get out of my house. Excuse me? You heard me. Get out. You are not welcome here. If you or anyone from the HOA sets foot on my property again without permission, I will call the police. Brenda's face flushed red. You're making a huge mistake. Do you have any idea how expensive this litigation is going to be? We have insurance and resources. We can drag this out for years. You will spend every penny you have on legal fees, and you will still end up with that sewer line on your property because eventually, one way or another, we will get what we need. You are fighting a battle you cannot win. We will see about that. Now leave. She left, slamming my door hard enough to rattle the frame. I watched her peel out of my driveway, gravel spraying from her tires. The preliminary injunction hearing 2 weeks later was more detailed than the TRO hearing. Marcus presented our full case, the title report showing no easement, the CCRs requiring proper easements, the survey showing the extent of the trespass, the arborist's report valuing the destroyed trees at $47,000, and the environmental consultant's opinion that the disruption could cause erosion and runoff problems affecting the lake. Stapleton tried a different approach this time. He brought in the HOA's engineer to testify that this was the only feasible route for the sewer line, and that without it, the Northside properties would continue to rely on aging septic systems that could fail and contaminate the lake. He argued that the public good outweighed my private property rights. Judge Simmons was not persuaded. Mr. Stapleton, I do not doubt that the sewer project serves a legitimate purpose, but the way to accomplish that is through proper legal channels. Your client needed to negotiate with Mr. Zimmerman. If he refused to grant an easement, then perhaps the county could have pursued eminent domain for a public purpose. But a private HOA cannot simply take property rights by fiat. The preliminary injunction is granted. No work may proceed on Mr. Zimmerman's property unless and until the HOA obtains a proper easement through negotiation or other legal means. After the hearing, Stapleton approached Marcus in the hallway. I hung back, letting the lawyers talk. After a few minutes, Marcus came over to me. They want to talk settlement again. They are offering $75,000 for the easement, full restoration of your property, planting of mature replacement trees, and payment of your attorney fees to date. What do you think? I asked. It is a substantial offer. But Keith, you need to understand something. If you do not settle, this is going to get ugly. They are going to argue that you are being unreasonable, that you are denying a benefit to the community. They might try to get the county to exercise eminent domain on their behalf. This could drag on for a year or more. And even if you win everything, you are still going to have that trench through your property that needs to be dealt with. Can I make a counteroffer? Of course. They have to remove everything they installed, fill in the trench, restore the grading to original condition, pay for replacement of all the trees with mature specimens of equivalent size, which is going to cost way more than $47,000. Pay for an environmental remediation plan, pay all my attorney fees and costs, and pay me $250,000 in damages for trespass and the permanent diminution in my property value. Then I will consider settling. Marcus raised his eyebrows. That is a tough counteroffer. I doubt they will go for it. Then we go to trial. I am not rewarding them for their bad behavior by giving them the easement they tried to steal. Marcus presented my counteroffer. Stapleton looked like I had asked for his firstborn child. They rejected it within 5 minutes. Then I guess we're going to trial, Marcus said. The next few months were a blur of legal maneuvering. The HOA filed a counterclaim against me, alleging that I was breaching the CCRs by unreasonably withholding consent for a community improvement. They sought a declaratory judgment that they had the right to complete the sewer line. They also filed a motion for summary judgment, arguing that as a matter of law, the CCRs gave them the authority they needed. Marcus tore apart their arguments in our response brief. The summary judgment hearing in July was almost comical. Stapleton brought in 3 different legal theories for why the CCRs should be interpreted to give the HOA easement rights. Judge Simmons shot down each one. Counselor, you are asking me to read words into this document that simply are not there. The CCRs say easements are required. Your client did not get an easement. End of story. Summary judgment is denied. This case is going to trial. The trial was scheduled for October 2024. As summer turned to fall, I spent a lot of time thinking about what I really wanted. The money did not matter that much to me. I had done well enough in my life that a couple of $100,000, while significant, was not life-changing. What mattered was the principle. The HOA had trampled over my rights, destroyed my property, and showed absolutely no remorse. They needed to be held accountable. Marcus and I spent hours preparing. We deposed Brenda Patterson and the other board members. The depositions were revealing. None of them could point to any specific legal advice they had received before starting the project. Brenda kept insisting they had consulted with attorneys, but when pressed for details, she could not remember who, when, or what they had been told. It became clear that the board had just assumed they could do whatever they wanted because they were the HOA. We also deposed the contractor. He testified that he had asked about property rights before starting and had been assured by Brenda that everything was approved. He had done his due diligence by checking the county permits, but he had not verified the easements because that was not normally his job. He seemed genuinely sorry about the whole situation. The trial lasted 4 days. Marcus methodically laid out our case. The undisputed facts about property ownership, the absence of any easement, the damage caused by the trespass, and the HOA's cavalier attitude toward property rights. Our experts testified about the value of what was destroyed and the ongoing impact to my property. The HOA's case was essentially, we meant well, and the sewer line is good for the community, so we should be excused for not following proper procedures. They tried to paint me as a selfish obstructionist who did not care about his neighbors or the environment. On the 3rd day, Brenda took the stand. Marcus cross-examined her, and it was devastating. Mrs. Patterson, before construction began on Mr. Zimmerman's property, did you personally review any legal document showing that the HOA had an easement on his land? We relied on our attorney's advice. That was not my question. Did you personally review any recorded easement? No, but I trusted that the proper procedures had been followed. Did you or anyone from the HOA ever contact Mr. Zimmerman before construction began to discuss the project? The project had been discussed at board meetings, which are open to all homeowners. Did Mr. Zimmerman attend those meetings? No, but the minutes are posted on the HOA website. Did you send Mr. Zimmerman a personal notice that you were planning to dig a trench through his property? The CCRs do not require us to give individual notice for infrastructure projects. Mrs. Patterson, is it your testimony that a homeowner should have to attend every board meeting and read every line of every meeting minute to know that the HOA is planning to tear up their property? Homeowners have a responsibility to stay informed about community matters. Marcus let that answer hang in the air for a moment. After Mr. Zimmerman objected to the construction and before the temporary restraining order was issued, did the board consider stopping work voluntarily to investigate whether you actually had the legal right to do what you were doing? Brenda shifted in her seat. We were confident in our legal position. That is not what I asked. Did you consider stopping? No. Even after Mr. Zimmerman explicitly told you he had checked his title report and there was no easement? We believed our attorney over a homeowner. Mrs. Patterson, at the time construction began, who was the HOA's attorney? Well, we were between attorneys at that moment. Mr. Stapleton's firm came on board after the construction started. So when you began this project, you did not actually have an attorney? We had consulted with our previous attorney some months earlier about the project. What was that attorney's name? Gerald Hoffman. And what did Mr. Hoffman tell you about easements? He said we needed to check the property records. Did you check the property records? Brenda's face was flushed. I assumed someone on the board had done that. Who on the board? I do not recall. Mrs. Patterson, is it fair to say that the HOA board approved and commenced a major construction project affecting private property without verifying that it had the legal right to do so? We made a mistake, Brenda said quietly. A mistake that destroyed 70-year-old trees and carved a 350-foot trench through Mr. Zimmerman's land? Yes? The next day, Stapleton put on a lukewarm defense. Their engineer testified again about why this route was optimal, but on cross-examination, Marcus got him to admit that there were other possible routes that would have used existing road rights-of-way and easements. They would have been longer and more expensive, but they were feasible. In closing arguments, Marcus made it simple. Ladies and gentlemen of the jury, this case is about whether property rights mean anything in America. The defendant, HOA, decided they wanted to run a sewer line through Mr. Zimmerman's land. They did not ask permission. They did not negotiate. They did not follow the law. They just started digging. When Mr. Zimmerman objected, they told him he was being selfish and unreasonable. They offered him money after the fact to excuse their trespass. But that is not how property rights work. You cannot take first and ask later. The HOA committed a clear trespass. They destroyed valuable trees and damaged Mr. Zimmerman's property. They need to be held accountable. We are asking for full restoration of the property, compensation for the damages, and yes, punitive damages, because this conduct was willful and malicious. They knew they did not have permission. They did it anyway. That deserves punishment. Stapleton's closing was defensive. He emphasized that the HOA was made up of volunteers trying to do good for the community. He argued that mistakes happen and that punitive damages were inappropriate. He asked the jury to award modest compensatory damages at most. The jury deliberated for 6 hours. When they came back, the verdict was everything I had hoped for. They found the HOA liable for trespass. They awarded me $89,000 in compensatory damages, covering the trees, the property damage, diminution in value, and my emotional distress. And then, the big one. They awarded $400,000 in punitive damages. Judge Simmons thanked the jury and dismissed them. Then he addressed the issue of my request for injunctive relief, requiring the HOA to remove the sewer line components and restore my property. Based on the jury's verdict and the evidence presented at trial, I am ordering the defendant, HOA, to remove all sewer line components from the plaintiff's property within 90 days. This includes all pipes, gravel, markers, and any other materials associated with the project. The defendant is further ordered to restore the property to its original grade and contours and to implement the environmental remediation plan proposed by the plaintiff's expert. The plaintiff is also awarded his reasonable attorney fees and costs to be determined at a later hearing. Stapleton stood up. Your Honor, the HOA requests a stay of the removal order pending appeal. The cost of removal, and then potentially having to reinstall if we prevail on appeal, would be prohibitive. Denied, Judge Simmons said. Your client should have thought about costs before they started digging where they had no right to dig. The order stands. Walking out of that courtroom, I felt a weight lift off my shoulders. It had been 7 months since that March morning when I first heard the excavator. 7 months of stress, anger, legal bills, and fighting. But it was worth it. The HOA did appeal. Stapleton filed a notice of appeal to the South Carolina Court of Appeals, arguing that the punitive damages were excessive and that the judge had erred in various rulings. Marcus was not worried. Keith, they are going to lose the appeal. The facts are too clear, and Judge Simmons did not make any legal errors. They are just delaying the inevitable. While the appeal was pending, the 90-day clock for removal was stayed, meaning the sewer line components remained in the ground on my property. But the HOA had to post a bond to cover the eventual removal costs, which meant they had to put real money on the line. During this time, I learned more about what was happening in the HOA. Brenda Patterson had resigned from the board in disgrace right after the verdict. Several other board members had also stepped down. There was talk of a special assessment to cover the judgment and legal fees, which made me very unpopular with some of my neighbors. I got a few nasty letters and one vandalized mailbox, but most people seemed to understand that the board had screwed up, not me. The new board president, a reasonable guy named Thomas Whitfield, reached out to me in February 2025. We met at a coffee shop in Anderson. "Keith, I want to apologize on behalf of the HOA for this whole mess. The previous board made terrible decisions, and you have been put through hell. I have been reviewing everything, and honestly, I'm appalled at how this was handled." "I appreciate that, Thomas. Look, I know we have an appeal pending, but between you and me, our appellate attorney says we are probably going to lose. The best-case scenario is they reduce the punitive damages a bit, but the core verdict is going to stand, which means we are going to have to remove that sewer line and pay you a lot of money. Money the HOA does not really have without a special assessment. That is not my problem. Your board created this situation." "I know. I'm not asking you to let us off the hook. What I'm asking is this. Would you be willing to sell us the easement now, at a fair price, in exchange for us dropping the appeal and paying the judgment immediately?" I thought about it. "What are you offering?" "We had an independent appraiser look at what a fair easement price would be, considering the permanent impact to your property. He came up with $200,000. Combined with the $489,000 from the judgment, that is $689,000 total. We drop the appeal, pay you immediately, restore your property as ordered by the judge, and get the easement we need. The sewer project benefits everyone, including you eventually. What do you say?" I talked it over with Marcus. He thought it was a reasonable offer. "Keith, you won. You proved your point. The HOA has been held accountable. If you take this settlement, you get your money now instead of waiting potentially another year or more for the appeal to resolve. And your property gets restored now. I think you should seriously consider it." I thought about those oak trees that were gone forever. I thought about that March morning when I watched strangers destroying my land. I thought about Brenda Patterson's threats and condescension, and then I thought about whether I wanted to spend another year fighting or whether I wanted to move on with my life. "Tell them I want $300,000 for the easement, not $200, and I want personal written apologies from every board member who voted to approve the project without verifying the easements. And I want the HOA to publish a full account of what happened in the community newsletter so every homeowner knows exactly how badly they screwed up. If they agree to all that, we have a deal." Thomas agreed. In March 2025, 1 year after the nightmare began, I got a check for $789,000. The HOA dismissed the appeal. Within 2 months, they had removed and properly reinstalled the sewer line on my property with a recorded easement. They brought in a landscape company that filled in the trench, regraded everything to the original contours, and planted 6 mature oak trees at $25,000 each to replace what had been lost. They implemented the environmental remediation plan. My property would never be exactly what it was before. Those original trees were irreplaceable, but it was healed. The scar was fading. The written apologies came from Thomas and the 3 board members who had voted for the project and were still in the neighborhood. Brenda Patterson had moved away and did not respond to requests for an apology. I did not care. She had been humiliated in court, forced off the board, and had become a cautionary tale in HOA circles around South Carolina. That was enough. The HOA newsletter in April 2025 published a detailed account titled "Lessons Learned from the Zimmerman Case." It explained exactly what had happened, how the board had failed to do its due diligence, and the costs to the community. It outlined new procedures to ensure nothing like this would ever happen again, including mandatory legal review of any project affecting private property and personal notification to affected homeowners. The special assessment to cover the costs was steep, about $1,200 per household, and I'm sure that made me even more unpopular with some people. But it was not my fault the previous board had been reckless and stupid. I spent some of the settlement money on additional landscaping and improvements to my property. I had a professional landscape architect design a native plant garden where the trench had been. I upgraded my dock. I built a stone patio overlooking the lake where I could sit in the evenings and watch the sunset. One evening in late May 2025, almost exactly a year after the trial, I was sitting on that patio with a glass of bourbon, watching the sun go down over Lake Hartwell. My phone rang. It was Marcus. It was, "Keith, you are not going to believe this. I just got off the phone with an attorney in North Carolina. He has a client in a similar situation with an HOA that ran a drainage line through his property without permission. He read about your case and wants to know if he can use it as precedent." I told him absolutely. "Your case is now being cited in legal briefs all over the Southeast." Is that good? It is fantastic. You did not just win your own case, Keith. You set a precedent that is going to protect other homeowners from HOA overreach. Judge Simmons's opinion is being taught in property law classes. You made a difference. After I hung up, I sat there thinking about everything that had happened. It had been exhausting and infuriating and expensive, even with the attorney fees award. There were times I had wondered if it was worth it, if I should have just taken an early settlement and moved on. But sitting there on my restored property, knowing that the HOA had been held accountable, knowing that other homeowners would benefit from the precedent, I knew I had made the right choice. Property rights matter. Due process matters. You cannot just let people or organizations trample over you because it is easier than fighting back. The sunset that evening was spectacular, all oranges and purples reflecting off the lake. A pair of herons flew past, heading to their evening roost. The cicadas were starting their evening song. My land was at peace. I had gone to war with my HOA over a sewer line they ran through my lakefront lot without an easement, and I had won. Not just in court, but in proving that even against organizations with resources and insurance and expensive attorneys, one person standing up for their rights can prevail. The sewer line was properly installed now, running through my property with a legally recorded easement that I had been fairly compensated for. The Northside residents had their connection to the county system. The lake was better protected from septic system failures. Everyone got what they needed in the end. They just had to do it the right way, the legal way, the way that respects property rights and the rule of law. And that, more than the money or even the restored property, was what mattered most. I had stood up to bullies with official-sounding titles and forced them to follow the same rules everyone else has to follow. The Lakeview Estates, HOA, learned an expensive lesson about property rights. And I learned that fighting for what is right, even when it is hard and expensive and uncertain, is always worth it. As darkness settled over Lake Hartwell and the first stars appeared overhead, I raised my glass in a silent toast. To property rights, to justice, to knowing when to fight and having the courage to see it through. The nightmare was over, and my lakefront property was truly mine again.